1968ခုနှစ်မြန်မာနိုင်ငံတရားစီရင်ထုံးစာမျက်နှာ4 Chief Court Civil Miscellaneous Appeal before U Jorzan U and U Chit Judges T.P.MAMMOOTTY Appellant versus the Secretary Ministry of Immigration and National Registration Respondent ဤစီရင်ထုံး audio book ကိုထက်တန်းရှေ့နေဦးအောင်ခိုင်ဦးထက်တန်းရှေ့နေဒေါ်ပြည့်ပြည့်ဖြိုးနှင့်တရားလွှတ်တော်ရှေ့နေဦးထိန်လင်းဦးမိသားစုကစီစဉ်သည် Specific Relief Act Section 45 The judicial principle of audi alteram partem hear the other party. The question whether it has been contravened must be judged in the light of the provisions of the relevant act. The appellant, a foreigner, prayed for an order under Section 45 of the Specific Relief Act to forbear from enforcing an order under Section 3 of the Foreigners Act. Hell, the judicial principle audi alteram partem, here the other party, popularly known as natural justice, varies with varying constitutions of statutory bodies, and the question whether in a particular case it has been contravened must be judged not by any preconceived notion of what it may be, but in the light of the provisions of the relevant act. For example, the Foreigners Act. It can be gathered from the provisions of the particular statute whether an administrative tribunal or body has a duty to act judicially. Section 3 of the Foreigners Act does not cast any duty on the chairman. G. Chan Yok versus the Controller of Immigration, Burma, 1951, BLR, page 197, SC. The State versus the Secretary of State for Home Affairs, 1917, IKB, page 922, Citran versus the Superintendent, Rangoon Central Jail, and another, 1957, BLR, page 190, High Court. Mohammed Ibrahim Salabhwai versus the Controller of Immigration, 1963, BLR, page 51, CC. The Bank of Chettinad Limited versus the Income Tax Assessment, Collection and Inspection Board, Rangoon, 1966, BLR, page 806, referred to. Utonyo for the appellant. Mr. S.K. Ghosh, Government Advocate for the respondent. U Jorzan U, Judge. In Civil Miscellaneous Case number 123 of 1966 of this court, the appellant, an Indian Muslim, prayed for an order under Section 45 of the Specific Relief Act, requiring the Ministry of Immigration and National Registration, Burma, Rangoon, to forbear for enforcing its order under Section 3 of the Foreigners Act, directing the appellant, a foreigner, to leave this country and to allow him to continue residing in the country. He complained that the Bureau of Special Investigation inquired behind his back about him on the false information received from letters written by persons not in good terms with him. Under Section 3 of the Foreigners Act, the chairman of the Revolutionary Council of the Government of the Union of Burma has discretion to order in writing any foreigner to leave the country or be deported forthwith. The trial court rejected the application with cause and withdrew the stay order. Hence this appeal, the appellant's advocate submitted that he was not pressing the application for stay of the order filed again in this appeal and prayed for permission to withdraw it. The prayer is granted. As per diary order dated 23rd October 1967, notice was issued to the respondent for hearing before the appeal was admitted, and we have had the appellant's advocate and the government advocate for the respondent for the purpose of admission of this appeal. We would like to point out that under Section 3 of the Foreigners Act, it is in the discretion of the chairman of the Revolutionary Council to make the order, and Section 45 of the Specific Relief Act says the Chief Court is not authorized to make any order binding on him. The relief under Section 45 is analog to the English writ of mandamus, and it is a high prerogative writ, but it is discretionary. Section 45F of the Act makes it clear that mandament is not applicable to the head of states. In Ji Chen Hyok versus the Controller of Immigration, Burma, 1951, BLR, page 197, SC. 1. Which is the leading case on the point, the late Supreme Court quoting the submission of the Attorney General in the state versus the Secretary of State for Home Affairs, 1917, IKB, page 922. Said, every country which extends its hospitality to an alien can terminate the hospitality and can do so by sending the alien back to his own country. In that case, Lord Justice Stephen E.D. said in the judgment, a Secretary of State is not required to justify in a court of law his reason for making a deportation order in the case of an alien. The same may be said of the chairman of the Revolutionary Council. The principle that a sovereign state has absolute power to deport an alien is accepted by international law. The authority was followed in Sitram versus the Superintendent, Rangoon Central Jail, and another. 1957 BLR, page 190, HC, where the bench said, in our opinion, so long as the person concerned is a foreigner, it is not for the courts of law to question the desirability or otherwise of his deportation under Section 3B of the Foreigners Act. This matter is entirely within the province of the executive authorities. In Mohammed Ibrahim Salabhwai versus the Controller of Immigration, 1963, BLR, page 51, CC, it was again laid down. It is a well-established principle in international law that foreigners enter a sovereign state only by permission and on the sufferance of the state, and they are liable to be expelled or deported from the state at the pleasure of the authorities who exercise the sovereign power of the state. This principle has found its place in such of our statutes as the Foreigners Act, Section 3 of which gives unbridled power of deporting foreigners to the government authorities, and there have been numerous decisions which have upheld this power. The advocate for the appellant submitted that the inquiry held in the absence of his client, who had no opportunity of cross-examination the witness, if any, is against natural justice, and relied upon a passage at page 368 of Maxwell on Interpretation of Statutes, 9th edition, in giving judicial powers to affect prejudicially the rights of person. A statute is understood as silently implying, when it does not expressly provide, the condition or qualification that the power is to be exercised in accordance with the fundamental rules of judicial procedure. That is to say, the person such to be prejudicially affected shall have an opportunity of defending himself. We agree, but in the instant case, the statute expressly provides that the chairman has absolute discretion to order any foreigner to remove himself from the country or be deported forthwith. Under Section 45 of the Specific Relief Act, the jurisdiction of the court is limited to cases where there is clear breach of duty to do or forbear from doing. As the case may be, that is to say, to exercise its discretion or refrain from exercising its discretion. Once that discretion has been exercised bona fide, its correctness cannot be challenged, nor can a party be directed to exercise the discretion in a particular manner. The Bank of Chettinad Limited versus the Income Tax Assessment, Collection and Inspection Board, Rangoon, 1966, BLR, page 806. This judicial principle, or the alteram partem, here the other party, popularly known as natural justice, varies with varying constitutions of statutory bodies, and the question whether in a particular case it has been contravened must be judged not by any preconceived notion of what it may be, but in the light of the provisions of the relevant act. For example, the Foreigners Act. It can be gathered from the provisions of the particular statute whether an administrative tribunal or body has a duty to act judicially. Section 3 of the Foreigners Act does not cast any duty on the chairman. There is no dispute that the order in question is an administrative order, and where the hearing is administrative, it comes within the executive power of the state. The concept of a quasi-judicial act implies that the act is not wholly judicial. It describes only a duty cast upon the executive body or authority to conform as far as practicable to norms of judicial procedure in performing some acts in exercise of its executive power. If the case was under Section 7(1) of the Immigration Emergency Provisions Act, it will be different, as Section 13A of that Act specifically place the burden on the accused of proving that he entered or remained in the Union of Burma legally in the inquiry or trial. The accused must be given an opportunity to discharge the burden before he is deported, and in case of failure to give the opportunity, the judicial principle, or the alteram partem, comes into play, and any deportation without hearing the accused is liable to be set aside. တန်ချောင်စင်းပါနှစ်အတွင်းဝန်လူဝင်မှုကြီးကြပ်ရေးနှင့်အမျိုးသားမှတ်ပုံတင်ရေးဝန်ကြီးဌာန 1961 BLR page 117 SC မတ်ဘီဂံဘဟာခါတွန်ပါ14နှစ်အတွင်းဝန်လူဝင်မှုကြီးကြပ်ရေးနှင့်အမျိုးသားမှတ်ပုံတင်ရေးဝန်ကြီးဌာနရန်ကုန်မြို့ပါ2 1961 BLR page 53 SC. The next point raised by the advocate for the appellant is that the trial court was wrong in deciding the case on a preliminary objection before the filing of the written statement. The appellant was no doubt given an opportunity to reply to the preliminary objections filed by the respondent, and the appellant did file a reply nearly 3 months after the filing of the preliminary objections. The court heard the arguments. It is clear from the record that the court had not yet felt that a written statement was required under Rules 1 and 10 of Order 8 of the Civil Procedure Court. The law does not prohibit the filing of objections on facts and or law to uproot or knock out a suit at the preliminary stage before the filing of the written statement. It is often very desirable in order to save time and trouble to raise preliminary objections and the court to accept such objections, especially on point of law. For example, limitation or res judicata or set-off. Such objections should in fact be raised at the earliest opportunity, as the entire suit can be disposed of without calling upon the defendant to file the written statement under Order 8, Rule 1 of the court. Similar objection was raised in Mohammed Ibrahim Slabwhite versus the Controller of Immigration, Supra 1966 PLR, page 760, and it was ruled thus. Mr. Basu will have me hold that the defendant cannot raise such a preliminary objection since he has not yet filed his written statement, and therefore, as it were, not yet fully in the picture. I do not, however, consider that to be a valid contention because it is at all times relevant in the trial of a suit to consider whether there is a cause of action or whether the plaintiff has asked for a relief which is within the power of the court to grant. If there is no cause of action or if the relief sought for is not within the power of the court to grant, then there is no point in going through the motions of the trial, such as the filing of the pleadings, the framing of the issues, and the hearing of evidence. Very recently, this court in Dosonyo versus Malajin, 1966 PLR, page 760, pointed out that no doubt the court, if so disposed, could have made a preliminary issue out of the written objection filed by the defendant and proceeded to try the same, and there is nothing to prevent it from fixing preliminary issue on the pleadings placed before it and proceed to determine such issue before the defendant has filed a full written statement. For all the reasons given above, we are convinced that there is no substance in this appeal. We see no ground to entertain it. It is therefore dismissed summarily.